The next case is Buchs versus Lorain County Zoning Board of Appeals. Each party will have 15 minutes to present their argument. The appellant will reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
Yes, 5 minutes.
Thank you, very good. I will note that I'm keeping time up here, so I will try to let you know there's about a minute left in your time. And then if you run into rebuttal time, I'll let you know your time is over, and if you use any additional time, it'll be into your rebuttal time for that. And I'll also try to let you know in about a minute in your time if we get to that.
Thank you, Your Honor.
The argument is being recorded, so when you come to the podium, first, please introduce yourself for the record. Stay behind the podium if you're able to, because we're visually as well as audio recording you, so we can see you and hear you, and if you move away, we'll lose that to some extent. I don't know that it really applies in this case, but you should not use the name of any child, minor, or victim. If you would be in that position, please use initials or something to that effect rather than their full name or some designation such as child or name. With that, we read your brief and are ready to proceed whenever you are.
Good morning, Your Honor. My name is Kenneth Broussard. I'm an Assistant Law Director for the City of Lorain, here on behalf of the City of Lorain Zoning Board of Appeals. This case relates back to an appeal, well, actually an original decision from the Lorain Board of Zoning Appeals that was thereafter appealed by Mr. Buchs and Ms. Hamanek, and Road to Recovery went to the trial court, and then we appealed that to get to this court. Initially, there was an application made by Mr. Buchs for a rental certificate, which means he wanted to rent out a piece of property that he owned. The application was actually made back in, I believe it was March 8th of 2019 was his initial letter. That letter related to 3 properties, 720 Hamilton, 740 Hamilton, and 754 Hamilton. Those were all abutting properties. All he indicated in his application was that he wanted those to be rental properties, as previously used as rental properties, subject to the additional condition that the people that live there be sober. That was it. He didn't indicate anything else in that application. He didn't say they were going to be providing services. He didn't indicate that there was going to be a different company involved, the Road to Recovery was going to be involved. He didn't indicate who those tenants were going to be or how it was going to be operated, just that he wanted them to be rental properties.
Well, counsel, wouldn't that wave a little red flag in front of the city in regard to the fact that when you say I'm only renting to sober people, I mean, there is nothing that, that allows a landlord to just, require somebody to be sober to live in the property, just under the landlord-tenant law or the Constitution.
Certainly, I mean, it may have, or maybe it should have raised red flag, but at least from the record, it did not raise a red flag at that point in time. They had been rental properties before, and when they came in and said, we want these to be rental properties, they just kind of went through the normal process of, well, they're going to rent it out, they're going to rent the house out, and most probably a family's going to move in as a single family rental. That's how they had been used in the past. Mr. Buchs indicated that's how they were going to be used, as they had been used in the past, and they had been rental properties. Lorain, the city of Lorain has a great deal of non-owner occupied homes, so they are rented out. They are typically just, you come in, you get a rental certificate, and then you rent the house out to a single family, or maybe multiple people, but it's as a home. You're not renting it out for business purposes. The appellee there indicates that they believe that somehow by getting that rental occupancy permit, it allowed them to do anything they wanted as long as they were renting it out. I'm not sure he's ever said that, or they've ever said it, but that's kind of like, we rented it out to a business, so we can operate a business there, because we have a rental certificate. No, a rental certificate just means that you can rent it out in accordance with the provisions of the zoning district that you're in. And the zoning district that they are in was an R2 zoning district. That provides for single family, duplexes, and multifamily. It does not provide for social service facilities. Social service facilities are prohibited in that area. They are only allowed in R3 districts and only allowed as a conditional use in an R3 district. In this instance, when we look at what a social service facility is. The definition pursuant to the city ordinance at that time, which was 122143, was a residential social service facility means a facility or home which provides resident services to a group of individuals of whom one or more are unrelated. The evidence at the hearing clearly showed that there was being rented to a group of individuals and that one or more of those individuals were not related. That condition was met. It then comes down to were they being provided with any residential services? Mr. Buchs and Ms. Tominick make a big deal out of the fact that they were not provided with any programming services. Well, if we continue on in the wording of the ordinance, it says, and which may provide additional services, supervised programming services. It doesn't have to provide programming services to be considered a social service facility. It only provides that it may do those. The ordinance also provides very clearly that facilities, that the category includes, but is not limited to, facilities commonly referred to as halfway houses and group homes. The testimony at the hearing clearly showed that this was being rented out to 10 different gentlemen at the time, at least 10 different gentlemen, and it was within a normal setting of a group home. The only testimony that Ms. Hominick entered with respect to whether or not services were being provided was in response to her attorney's questioning, where the question was, are you providing any programming services? She said no. That was her testimony. She wasn't providing programming services. She never indicated that she wasn't providing residential services. In fact, in response to the questions I asked her, she specifically said what they were providing. She was providing them with she provided them food. They cooked the food. She provided it. She provided them with toiletries. She provided them with utilities, everything else that you would need to have a residence, except she said they weren't providing programming services. That doesn't mean it wasn't a social service facility, because that was an optional thing that could be provided, not that it had to be provided. The testimony at the hearing clearly showed that they were providing resident services, and it was a group home. As a group home, and they were...
How is this necessarily a group home? What your definition of group home is any time non-family members live together, that makes it a group home?
No.
These aren't folks that have mental health issues, we typically see in a group home, or with DD boards, those type of things. They're folks that have sober issues. Does that automatically make it a group home?
No, it doesn't automatically, but when you have a central kitchen, when the owner of the property is providing you with food, but then you're cooking it, when you're assigning chores for the individual people to do, when they are being assessed and monitored, for sobriety, I believe those factors together end up making it a group home. I mean, it's effectively, it wasn't presented as that. If not a group home, it was certainly a boarding house, which would also not be allowed within the R2 zoning district.
Is that somewhere else in the code? A boarding house is not involved in R2 and not in the section we're talking about?
That's correct.
Residential services?
Yes. And that actually, I raised that issue at the hearing itself, because the actual notice that went out to to Mr. Buchs and Ms. Hominick was that they were operating as a social service facility, and they weren't really notified that they were, they weren't, the notice didn't say that they were improperly operating as a boarding house. In my opinion, it could have, but it didn't. And so we indicated at that point in time in the hearing, I indicated that we were just looking into whether or not it was actually a social service facility at that point in time.
And you correctly point out, I think in your brief, of course, our scope of review is limited. That's from the trial court. The trial court looked at all this and made a factual determination based upon some testimony that there wasn't reliable probative evidence. We're looking at that in essence for an abuse. So why should we say, trial court, you got this so wrong that this is an abuse? What is the evidence of trial court? Why is that defective?
Well, I think the trial court, in its finding, ultimately said that the zoning board, or that the city, failed to show evidence that was able to rebut the plaintiff's testimony that no social service facilities were being provided. Well, the thing is, the trial court completely missed that. Because when you look at the record, there was never any testimony that no residential services were being provided. The only testimony by Ms. Hominick was that there were no residential programming services being provided. And when you look at the whole record, even from Mrs. Hominick's
Grab
direct,
about a minute of your time.
thanks. From Ms. Hominick's direct testimony, she testified with respect to, one, the brochure, and that the brochure that was there, the Road to Recovery brochure, was the intent that that was going to apply to all three houses. One of the witnesses, and I believe it was Laura Holmes, also testified. She was the county employee who came out there. She testified that she was given that brochure. It was an understanding that the brochure applied to all three of the houses that they were putting together at that point in time, even though at this point in time, only 720 was in operation.
Counsel, how did she describe the home? How did she describe, the city's person describe the rental property?
Meaning Laura Holmes?
Yes.
Well, that Laura Holmes wasn't the city person.
Oh, I'm sorry,
She was a county employee
county.
that was dealing with the recovery court that was sending people out to that
Okay.
facility.
And how did Ms. Holmes describe the facility?
Right offhand,
Okay.
I'll
We'll
have to look.
that's fine.
I'll have to look at the.
I thought she said they were not offering social services, or residential social services at the facility.
No, that was different. That was a different individual.
Okay, that was a lady from the mental health board.
Yes, she classified it. She deemed it to be. Forget the exact word she used. I'd have to look at the transcript to find out exactly what she said.
But I thought the gist of her testimony was these folks aren't offering residential services at this facility. It's a sober house or whatever she called it, but it's not fitting in the category of this particular part of the zone.
Within that, that was a federal government program, I believe, a state government program that she was associated with. And even though she said it was not necessarily, she didn't believe it was a social service facility within that framework, it wasn't within the definition of what our code says, or what the city code says a social service facility is. I reserve the rest of my time.
Thank you.
Thank you.
May it please the court and opposing counsel, I'm Ryan Gambala, Dooley Gambala, McLaughlin, Florida, Sheffield Village, Ohio. I'm here today on behalf of the appellees, Don Buchs and Tracy Hominick, in this matter. We're here today because there was a change in the prevailing political winds in the city of Lorain, and it led the city to try to undo something that it got right the first time, to the detriment of the appellees. Appellees were issued a rental certificate of occupancy, and after a new mayor took office, they tried to take appellees' ability to use the property in conformance with that certificate of occupancy that they've been issued. Now, to accomplish this feat, the city asks us to ignore its own ordinances, its own procedures, and perhaps most importantly, the testimony of its own witnesses at the Zoning Board of Appeals hearing. The trial court wasn't persuaded, and this court shouldn't be either. Instead, appellees should be permitted to continue using their property consistent with the rental certificate of occupancy that the city of Lorain issued to them. And in this manner, they've done so for the last 5 years, since these proceedings all kicked off without incident. Now, in this case, there are a couple of things that I think the parties agree to, or at least that aren't in dispute, and I think they're important. The first one is the standard of review. Judge Stevenson, I think you maybe touched on it earlier. Both sides agree that the standard of review is set forth in Ohio Revised Code, Chapter 2506, where an administrative decision is appealed to the trial court, and the trial court has issued a decision. The Court of Appeals jurisdiction is to hear questions of law. In the Supreme Court case, Cleveland Clinic Foundation versus Boarding Zone of Appeals, they set forth the standard of review, and I'll quote it because I think it's important. The Supreme Court said, "The standard of review for courts of appeals in administrative appeals is designed to strongly favor affirmance. It permits reversal only when the common pleas court errs in its application or interpretation of the law, or its decision is unsupported by a preponderance of evidence as a matter of law. This is amongst the toughest appellate burdens to meet. There's no argument here, I don't think, that the trial court erred in its application or its interpretation of the law. Instead, the argument seems to be that the common pleas court decision was simply unsupported by a preponderance of evidence as a matter of law. And respectfully, we submit that the city got it wrong. The other thing that I think both sides can agree on that is critically important is the chronology of events here. It's important because we know that the city didn't consider Appellee's property to be a residential social service facility until a new mayor took office. So when the Appellees bought the property at 720 Hamilton Avenue, everybody agrees it was in a dilapidated state, and as soon as they bought it, they undertook efforts to improve the property. That is not disputed, it's in the record. The property's in an R2 zoning district. Now, on March 8, 2019, Appellees applied to the city for an occupancy permit at 720 Hamilton Avenue. As part of that application, the Appellees notified the building department in writing that the property's usage is the same as previously used, being rental apartments, specifically for the sober. I do want to correct one thing that was said earlier. That writing is in the record, and that writing is not related to 740 Hamilton Avenue. It is not.
It seems to me though, they assert there's some testimony that the folks involved with these houses, whether Mr. Buchs or someone else, that we want all these houses to operate on the same principle. Is there testimony to that effect?
There's not testimony to that effect. In fact, the testimony is to the opposite, which is that the pamphlet itself was aspirational for a different property at 740 Hamilton Avenue, and that's why I'm pointing out that the written submission to the city doesn't reflect 740.
And who testified to the fact that they were kind of, this was 740 and not 720?
Ms. Homnick did, Your Honor. And I've got some quotes in here, I'll read them as we go along. There was a discussion at the time they submitted their application about whether it was a residential social service facility, which in part is, at least what I understand, to be why this written submission was part of their application. And it was determined that the property was not a residential social service facility. So a couple of weeks later, March 25th, 2019, the application was March 8th. By the 25th, they then issued a conditional certificate of occupancy. As part of that, an inspection was done of the property. There were some nits, I guess, and things that had to be cleaned up at the property, some last-minute corrections and so forth. And on May 16, 2019, the city issued an unconditional rental certificate of occupancy for the property at 720 Hamilton Avenue. Now, the issuance of that certificate is critical as it relates to the city's codified ordinances and what was involved in issuing that certificate of occupancy pursuant to the city's own codified ordinances. Lorain Codified Ordinance 1213.02, at least as it existed at the time, required that before a certificate of occupancy is issued, the chief building inspector must determine that the use of the property or occupancy is in conformity with the zoning ordinance, and that the certificate of occupancy shall be issued only in conformance with the zoning ordinance. In other words, before the certificate of occupancy could be issued to Appellees, the building inspector confirmed that its use as rental apartments for the sober was permissible in an R2 zone where it was located. There's another ordinance, 1131.08. In this ordinance sets forth that the city could not have issued Appellees a certificate of occupancy had it determined that their use of the property was a residential social service facility.
Counsel, this is all interesting, okay, but that wasn't what the court decided this case on, right? The court said there was no residential services provided, and therefore that it didn't constitute a residential social service facility. And that's all that's in the ordinance, so it's an examination of the definition or what constitutes a residential social service facility, and that's what the court said that they got wrong, and that there is no evidence, rebut the fact that they did not provide social services,
Great. And
resident services, I'm sorry.
thank you, Your Honor. Let me skip ahead, just maybe in conclusion on that point, what I would say is that at bottom, the city issued a certificate of occupancy for FLEs to use the property as rental apartments for sober tenants in an R2 district because the building inspector had reviewed the property, determined it wasn't a residential social service facility, and didn't need a conditional use permit. Those steps would have had to have taken place under the Lorain codified ordinances for that certificate of occupancy that issued, and it was. But moving ahead, Judge Carr, to the point you raised about the evidence supporting the notion that this is not a residential social service facility, Lorain codified ordinance 1221.43 sets forth that a residential social service facility is a facility or home which provides resident services to a group of individuals of whom one or more are unrelated, and which may provide additional supervised programming services. Now, the evidence that was presented at the ZBA hearing is clear that they don't provide services at the property. Ms. Hominick testified, and she was asked, and I'll quote it, the question was, at 720 Hamilton Avenue, do you provide programming services to tenants? She answered, quote, no, I do not. They just live there, that's it, close quote. Besides Ms. Hominick.
Let me ask you this, okay? I haven't had a chance to look at the record yet, but obviously there was a decision by the Board of Zoning Appeals. And the BZA, did they write an actual opinion with findings and so forth?
I don't believe, I think there was just a roll call vote at the end, Your Honor.
So there was actually no written decision? Okay.
I'm going back to 2019, and I don't remember it.
Okay, that's all right, you get a chance to rebut.
But-
But I guess the reason I'm asking is because we're looking at this as an abuse of discretion, basically, and I understand that. But the trial court didn't have unlimited de novo review. The trial court had to look at the evidence and the interpretation of the ordinance by the BZA and determine whether or not that was unconstitutional, arbitrary, or unsupported by common credible evidence.
Sure.
And so I guess I'm wondering, how did they define resident services, for instance?
Well, and I think that's a great question, Judge Carr, and I think that comes back to the testimony of a witness that the city brought to the hearing specifically to testify on that point, and that's Elaine Georges. She was the interim executive director of the Mental Health Addiction and Recovery Services Board. She was brought in by the city to address that very issue, and her testimony was that this property is different than a social services agency, and she continued to say, this is a quote, I would say what you're hearing and what's being talked about is more recovery residents versus a social services program. That's the city's own witness saying that this isn't a service program, that this is a residence where tenants who happen to be sober are renting apartments.
But
Now,
they were subject to drug testing?
they were not. There was a hypothetical question about whether somebody could be tested if they showed up drunk, but there was no evidence that that actually occurred for anyone.
I understand, but what was the answer to that?
The answer was that they could administer such testing if something like that had occurred, but there was no evidence that it had.
Right, but doesn't the ordinance speak in terms of future too, that could be provided? Services that could be provided?
I believe the ordinance speaks to services that are provided.
Well,
And I
let's
think-
talk about what services are provided then. We had a program manager who enforced the rules. One of the rules was to be sober.
So,
That was certainly a rule of the home. Was there any written rule or anything else that said if there was a question, they could request drug testing or have drug testing done?
none of which I'm aware, Your Honor. And in fact, the testimony about the house manager is basically that he made sure doors were locked, that lights worked, things like that. He acted akin to a property manager. Now, where I think there's some confusion in the record is related to this pamphlet. And the pamphlet is related to 740 Hamilton, not the address that's at issue, not the property for which a notice of violation was issued.
So counsel, how would that drug testing, should it have hypothetically occurred under those conditions, how would that have transpired?
Well, Your Honor, I don't rightly know, because it's not something that ever occurred. I think the issue was, there may have been a question posed at the hearing that said, well, what do you do if somebody comes back drunk? I don't know that it was drug testing. This wasn't a function of administering any kind of regular drug testing or sporadic or surprise drug testing. It was a function that Ms. Hominick was asked a hypothetical question about what would happen if somebody came back drunk. And I believe her answer was that they wouldn't do that if that happened, that they would leave of their own volition. And there was a question asked that, well, would you or could you do some kind of sobriety test? And the answer, I believe, was that yes, I could or I would. But this was in response to a hypothetical question for a scenario that had never actually arisen, and hasn't, to my knowledge, in 5 years.
Well, counsel, it raises another question. I don't know if this was addressed at the hearing or not, but they said they would voluntarily leave, but if they didn't voluntarily leave, you couldn't evict them under the landlord-tenant laws in the state of Ohio.
Yeah, and that may be an issue between landlord and tenant. I don't know, I can't speak to, I guess, maybe what could have happened in that scenario. I understand the court's point, though, that,
Well, because the point was you had submitted this as a regular rental property.
correct.
But the regular rental property is not, it would have to be in line with the, I'm sorry, I'm losing my train of thought here. It would have to be in line with the landlord-tenant law, and the landlord-tenant law clearly doesn't allow you to just evict somebody because they're drunk.
About a minute left of your time.
Thank you, Your Honor.
So I'm just trying to piece it all together, how it all works together.
Sure. Well, I think the way that it works together is that these tenants understand that the rental unit is set up for folks that are trying to maintain sobriety, and that they work they work to maintain that sobriety as part of staying in that home. I think the critical point, though, is that this was all made aware to the city at the time they issued the rental certificate of occupancy. It was right in the paperwork that was submitted on March 8th, 2019. And the city reviewed it and issued the rental certificate of occupancy because they understood, consistent with their own witness at the ZBA hearing, that this wasn't a residential social service facility. The other point I want to make just in the time I have left relates to the Fair Housing Act.
Well, your time is up now, and I think that's a good point. You may briefly conclude at this point in time, if you would.
Thank you. For the reasons set forth, I would submit that there were no errors of law made by the trial court in its decision, and that the decision of the trial court should be affirmed and the appeal dismissed.
Thank you.
Thank you.
Thank you. With respect to the testimony of Elaine Shorters, the counsel left out a little bit of her actual quote from the transcript. She did say, I would say what you're hearing and what's being talked about is more recovered residents versus a social service program, but I am not the interpreter of that. Another department can help clarify that. So she didn't come out and make a pronouncement. She didn't make a final determination. She said, she's saying that it wasn't even within her area of expertise to make that determination.
And was somebody called to clarify that?
No, not at that hearing.
Okay, thank you.
With respect to the testimony of Ms. Hominick with respect to the pamphlet and whether it applied to the 720 property as well as the other properties, if I could take a moment, I'm going to read from her actual transcript. This is page 24 of the transcript. I don't think I understand the question. 720 is the only one we're discussing today from what I understand. 720 is occupied. My question, does anyone occupy 740 at this point? They do not. No one. Not right now. And so you're saying that 720 isn't following the same framework that you had set forth in the 740 pamphlet. This was a general statement that when this project was completed with all of these houses, what I wanted it to do, what my vision was for this. And my question, if you look at them, what's your vision for all three of these houses? If you look at the second page, living at the houses, yes, you have numerous bullet points. So it's basically, she's saying, yes, that's her vision for all of the houses, all three of them, including 720. Contrary to what council may be saying, she was in fact, when you look at the totality of her testimony, she's certainly saying that that pamphlet was intended to be her vision for all three of the homes. And I'm not going to get into this. She testified extensively at the hearing. But it's certainly not necessarily as represented that she said it was not going to apply to 720. It was supposed to apply to 720, 740, and 754.
Was there a written decision?
I believe there was an actual written decision. It may not be part of the actual record, but my recollection was an actual written decision was issued and sent after the hearing, which would have been the standard practice.
Well, that would have to be appealed too.
Yes, it was appealed.
Well, I understand. I'm just trying to figure out what is a friend of trial court, but we'll look at the record.
With respect to in Kissel versus Sandusky, the Ohio Supreme Court basically set forth the standard of review. And a court of common pleas should not substitute its judgment for an administrative board, such as the Board of Zoning Appeals, unless the court finds that there is not a preponderance of reliable, probative, and substantial evidence to support the board's decision. That's where I'm saying is the trial court in its decision, as a matter of law, violated its requirements. Because when you look at the actual record, the record itself showed that there was a preponderance of evidence in support of the Zoning Board of Appeals decision that this was a social service facility within the meaning of the city's code.
About a minute of your time left, please.
All right. Laura Holmes was the county employee. It's set forth on page 64 to 70 of the transcript. She also indicated that she was given that pamphlet, and when she was given that pamphlet, it was effectively her belief that it applied to all of the homes there, and she was with the recovery court. And because of this, I believe that the trial court overstepped its bounds, that it incorrectly decided that there was no evidence before the Zoning Board of Appeals to support its finding that this was a social service facility within the meaning of the City of Lorain Code, and that therefore the decision of the trial court should be overturned, and the initial ruling of the Zoning Board of Appeals terminating the operation should be upheld. Thank you.
Thank you. The court will take the matter under advisement, will issue a decision in due course. And that decision is released to be mailed to you by the circuit court, also available on the Ohio Supreme Court website. With that, on behalf of the court, I'd like to thank you both for your brief testimony.